in Rajiv Thapar versus
The dispute also raises issues concerning the exercise of inherent jurisdiction of the High Court in relation with questioning of an FIR or a criminal proceedings, requiring participants to carefully balance the rights of the accused.
FIR number 47 of 2025, registered before the police station cybercrime. Thus, the factual matrix of the present case in brief are the effect that I am not a 22-year-old engineering final year student at Eastern Valley University. The allegations in the present FIR against me are to the effect that I have allegedly intruded into the university examination system, and thereby 48 students' answer scripts were altered and marks were changed. This, my lords, in our submission is absolutely false. And, my lords, therefore, in the present matter, we pray that the FIR and the emanating proceedings thereof ought to be quashed. Lords, I shall be dealing with issue number 1, 2, and 3. Lords, issue number 1 and 3 dealing with the merits of the allegations and as to why the FIR ought to be quashed by this Hon'ble Court. On issue number 2, my lords, I shall be dealing with the legality of the search and seizure which has been conducted against me by the investigating authority. If your lordships may be kind enough to have a copy of our compendium of judgments through the result. And it is right to say that one person alone can never be held guilty of criminal conspiracy for the simple reason that one cannot conspire with consent. This has also recently been relied upon the lords in the decision of Manoj Soni versus the state of Madhya Pradesh. You can also find that page number 20 of the comment. Moving on to the next case, lords, which is the offence of cheating, as to how it is not made up. Lords would see the decision in Delhi raised by Fairfield, which deals with the essential ingredients of the offence of cheating. Lords, page number 17 for me. I'm so sorry, page number 12 and 13 for me. Lords, has that. Page number 12, the last paragraph. Similarly, in respect of an offence under section 420 IPC, because this is now 318 and 319 in UILS, the essential ingredients are: number 1, deception of any person either by making a false
and it also written that there is unauthorized access to sessions number 114. So what do you have to say on that part?
Plus, dealing with the first query that my lordships raised. Plus, as far as the essential ingredients of offences are concerned, because the offence of cheating and conspiracy, the essential ingredients are absolutely absent in the present matter. Therefore, we must be invoke Bajandal to say that the prima facie offence, according to the allegations of the police itself, is not made up. Secondly, perhaps dealing with your lordship's query or with respect to perhaps the tracing of access of the sessions, which is apparent in para number 7. Perhaps I shall be dealing with it in the next string of my arguments. Perhaps the argument of the petitioner therefore is that this allegation is supported only and only by the electronic evidences.
So what do you have to say on that part? Specifically naming Riyamu.
As far as those evidences are concerned, the argument is that these evidences are not legally admissible in nature, since they suffer from incurable legal defects, which I shall be substantiating in the next claim. As far as queries is concerned, on the aspect of criminal conspiracy, Because it is not the case of the prosecution herein that they have not been able to identify the co-conspirator. Had that been the case, that may have warranted a further investigation in the matter. Because what the police says is that the investigation is complete, a charge sheet is
focus getting rid of that very discount that was on 319, that is cheating by personal. You may grant it in your favor, maybe there is no cheating by personal.
Yes.
Is it a case where even cheating is not paid?
Yes,
So you have test on the entry of 318.
yes.
Also 319, because you are not the applied person who have access.
Yes.
You use that fake authentication and then thereby
First,
impersonate.
first need 318,
Yes.
and then maybe we can examine whether 319 is also attracted or not.
Please, I shall read out Clause 318 for a moment and then touch upon Manoj's queries on 319. Clause cheating 318. It says, whoever by deceiving any person fraudulently or dishonestly induces that person so deceived to deliver any property to any person, or to consent that any person shall retain any property, or intentionally induces the person so deceived to do or omit to do anything which he would not do or omit, if he were not so deceived, and which act or omission causes or is likely to cause damage or harm to that person in body, mind, reputation, is said to cheat. Therefore, Manoj, I say that there is no deceiving of any person involved according to the prosecution case. Secondly, Manoj, there is no inducement. Thirdly, Manoj, there is no delivery of property as such. Third, on the next query raised by my lords on 319, Manoj, cheating by personation. Manoj, if the offence in 318, which is Manoj of cheating, is not made up, due to Manoj the three reasons that I just canvassed before your lordships, the offence of 319 cannot be made out for the very simple reason that 319.
So at this sitting, the offence is very much found there, and you are in the system. Your marks have been increased or decreased or like that, and then certain things have been recovered also from you. So the prosecution is right in it that they should proceed with it, or to suggest, or they should proceed with it in this critical situation. More appropriate is that they should proceed ahead with the case. They should not get there.
You asked a question of FIR. The question is extraordinary part on one. And then another thing is that it's been written that 48 students marks are also affected. But do you think that we should proceed with this thing because 48 students are also affected by whatever has been increased or decreased as the case may be? So question is, we're just putting an end to it. Why shouldn't we proceed with it? Because the other students, 48 students is not a less number. It is also affected. Why shouldn't we proceed with it? Why are you after this question?
And I found one of the judgments authored by Justice Gauba itself, or whether that can be permitted or not. But I need to
the CGI,
please.
Supreme Court of India,
Yes. Now, I need to distinguish not between the requirement of the old code and the new code. Now, old code did not say that there was a hashing requirement.
Okay, go ahead.
The new code therefore says not that there is a hashing requirement which needs to be done at the stage of the seizure itself. This new requirement would therefore mean that the certificate along with the hash report needs to be presented at the stage of the seizure itself or by the time the charge sheet is filed before the court. Now, for this, your lordships may also have the decision of the Supreme Court of Rajendra Bihari Lal versus State of UP. I have supplied that to the researcher. Now, see para number 133. Now, in the present matter, which I am just referring to, the Honorable Supreme Court has quashed the entire criminal proceedings on the test that there was an incurable legal defect. Along with the material collected during the course of investigation lacked credibility. This is not exactly where I fit in, and therefore I refer to para number 133. Thus, in light of the aforesaid discussion on facts as well as law, We are of the view that FIR number so and so not only suffers from an incurable legal defect, having been lodged by a person not competent to do the same as per the then prevailing statutory scheme, but also the materials collected during the course of investigation lack credibility and fall hopelessly short of the standard necessary for permitting criminal prosecution to proceed on the strength of such material. The hands of the court cannot be said to be tied, where on overall view of the matter, it appears that the continuation of the criminal proceedings would result in travesty of justice, even when the material gathered may satisfy the ingredient.
There have been many loopholes and passwords, but why don't you report that? As a sincere student, as a brilliant student, why do you not go and quote the authorities, so on and so forth?
Because it is my case that I was not aware of these vulnerabilities and neither was I was involved in exploiting these vulnerabilities. Apart from this, an independent agency of the state had in fact reported all these lapses, the security lapses, to the concerned university officials and the private vendor. However, both of them, the private vendor and the university officials, failed to have any rectification made. And that is not the next issue with respect to the liability of the private vendor and the enhanced criminal liability as the state argues, which is not being dealt by the economic movements.
For the reported cyber breaches in the examination and evaluation method. To this, the petitioner submits that the alleged cyber breach in the examination and evaluation system is completely attributable to the systematic failures of the private vendor, which is Edutech Solutions Private Limited, and the Eastern Valley University Administration. My lordships, my relevance of pointing to the liability of private vendor here is not merely to determine their civil liability, but also to demonstrate that the examination system itself suffered from cybersecurity vulnerabilities. And when the very infrastructure relied upon by the prosecution is flawed, attributing criminal liability to the petitioner based on a flawed system becomes unreliable and legally unsustainable. Because everyone, including me, has a fair right to investigation. And by the investigative bias of the agency here, my right got void. My lordships, I will be substantiating my arguments based on the following points. That firstly, Edutech failed to implement reasonable security practices which triggers direct statutory liability. My lordships, Edutech here is that they had a non-delegable statutory duty under section 43A of the IPR, which mandates that such body corporates shall adopt, implement and maintain reasonable security practices and procedures. However, para number 5 of the Moot Proposition, which you will refer to in the compendium, page number 2, clearly shows that Edutech, lordships, page number 2, para 5 of the compendium. Yes, my lordships. The Moot Proposition itself, para number 5. The proximate cause of the breach. My lordships, I would also like to mention that Edutech here did not invoke section 79 safe harbor protection, which is available to intermediaries, because of the fact that in Google India Private Limited versus Visakha Industries, my lordships, page number 65 of the compendium. My lordships has that. Yes, my lordships, it explicitly mentions that the lawgiver has given protection from liability not unconditionally. It is for the service provider to prove that the offence of contravention was committed without his knowledge. He is also to prove that he has exercised all due diligence to prevent the commission of such offence or contravention. However, my lordships, in para number 6 of the Moot Proposition itself, which I shall read to you, shows that on 28 May 2025, my lordships, para 6, page number 2 of the compendium. On 28 May 2025, EBO detected suspicious activity, including 5 simultaneous logins from different locations, which were, my lordships, done through a foreign VPN. The vendor here had a liability to at least detect such simultaneous logins which were from disparate locations through a foreign VPN, which in DOK did not perform. there was a sudden burst of database edits between 2:30 AM and 4:41 AM. The use of an unauthorized SSH key checks some mismatches in 48 digital scripts. Mallochik, here the primary vendor could at least deploy and automate the Indian Computer Emergency Response Team guidelines mandate for private vendors like EdTech to report any such breach within 6 hours. However, Para 6 evidently proves that it was the university who filed the complaint and not the private vendor, so it could not even maintain the due diligence of filing the complaint to report a cyber breach that happened in their very own system. My second point is that the one vendor had cleared the fundamental breach of duty of care, which results in their liability. EdTech was contractually engaged to safeguard EMS integrity, which is a system integral to trapezium style education framework. However, the fed-up pre-breach warnings and the post-breach warnings show that the system had poor cybersecurity practices, which elevates their negligence to gross negligence, which warrants joint and several liability. Mallochik's prosecution story accuses Rian based on the digital trade tracked through the same EMS system, which is being managed by the private vendor. By establishing that the digital trade was received from a flawed system, having no security measure and due diligence, a reasonable doubt is created, pointing to the fact that the entire digital trade is tainted and flawed, and thereby it provides.
1 minute only.
Yes.
Merely because there were lapses on the part of the agency to have the proper security measures permitting to breach the same.
No, Mallochik, it does not permit. It does not permit anyone to breach the system. But my point here is that the system had vulnerabilities, it had flaws. But instead of looking at that angle, the prosecution story scapegoats the petitioner here by fixing the whole liability onto him when the private vendor and university were equally at fault. So the right to fair investigation is completely violated here by ignoring that angle.
What was pointed out probably was this. There were at least 5 hands in the cookie jar, and yours was one of them, because some evidence connecting you with those unauthorized logins has surfaced. So even if we can't identify those other 4 hands in the cookie jar, why should we allow you to get away when you have gained wrongfully?
Mallochik, the prosecution has no evidence as to the fact that he was one of the 5 involved or he was the only one involved. They are merely accusing my client here for the entire cyber breach by ignoring all other angles, even ignoring that so far no evidence substantiates his cause. Mallochik's my third point, which is that the investigative agency has an investigative bias which amounts to abuse of the process of law. Mallochik, it is a settled principle of criminal jurisprudence that investigation must be free and fair. A fair investigation demands impartiality, transparency, and exploration of all leads. However, the confidential report, which is referred to in paragraph 4 of the Moot proposition, Mallochik's the very end lines states that while routing their activities to multiple foreign VPN, the breach was conducted. However, the state here again has ignored these angles, which
affects the public examinations, and the public examinations that override the rights of the other 48 students override the individual convenience of the Riyan Verma.
You have made certain allegations against it. Are we entitled to go into the material on the basis of which you have made those allegations, or we have to simply go by your allegations?
Is already been established by the prosecution, and thereby their allegation fails.
Probably you didn't understand one thing. Does Bansal say that we are to simply go by your opinion?
No, Your
Or
Lordship.
can we look into the material, the evidence on which you have formed the defense?
That is what the counsel would like to say, that the allegations made are not purely opinions. Evidence in support is produced before the bench, and there were multiple devices seized and produced. If the
EMSS and the ID and the ITA. This is a lawful exercise of state power and not the rights infringement. Second, the allegation of conspiracy is fortified by both circumstantial and digital evidences. This Honorable Court has repeatedly affirmed in Kehar Singh versus State, the bench court referred to page 88 of the continuous loggings from different locations, the use of an unauthorized SSH keys, deletion of audit logs. The deletion of audit logs are not, these are not mere small things which could be done. The audit logs
admissible evidence, therefore Milords being squarely covered by the decision in R.P. Kapoor. On the first limb, Milords, the offences which are not prima facie made out, Milords, includes the offence of conspiracy and cheating. Milords, may have for a moment the allegations against me, the moot proposition, para number 7, Milords, page number 2. Milords, this is a matter of fact that I have been charged with criminal conspiracy as is apparent, Milords, from para number 6 of the moot proposition. Milords, may then have para number 7, the case of the prosecution hearing. Milords, have that? Milords, para number 7. The police placed one of the unauthorized access sessions to room number 214 of Riverview Hostel, occupied by 22-year-old final year student Riyan Verma, who is known for his coding skills. The police alleges that Riyan shoulder served evaluation.
Now we request
Professor Shivani Goswami, Ma'am, Dean USLLS, DGS IPU. Huge round of applause for them.
सभी न्यायाधीशों, विशिष्ट अतिथिगण, पूरे देश से आए पार्टिसिपेंट्स एंड स्टूडेंट्स, नमस्ते, गुड आफ्टरनून। मैं फेयरफील्ड इंस्टीट्यूशन की तरफ से, फेयरफील्ड ग्रुप ऑफ इंस्टीट्यूशन, फेयरफील्ड मैनेजमेंट ट्रस्ट की ओर से फेयरफील्ड कॉलेज कैंपस में आयोजित लीगल एकेडमिक फेस्टिवल मूट कोर्ट कंपटीशन 2026 में मंच पर बैठे सभी हमारे गणमान्य व्यक्ति, ऑनरेबल जस्टिस आर.के. गाबा जी, फॉर्मर जज दिल्ली हाई कोर्ट, मैं आपका बहुत बहुत आभारी हूं कि आपने समय निकाला और एक बच्चों को नई ऊर्जा मिली आपके आने से, धन्यवाद। मिस्टर नेहरू कंबोज, प्रेजेंटिंग ऑफिसर, नेशनल ह्यूमन राइट कमीशन, NHRC हमारे इस मूट कोर्ट कंपटीशन में कोलैबोरेशन में है और इन्होंने बड़ी मदद करी है। एक एनजीओ या कोई भी सोसाइटी एक दूसरे को मदद करती है तो अच्छा लगता है, लेकिन स्टूडेंट्स को आपने बड़ा बहुत ज्यादा इनकरेज किया और NHRC हमेशा साथ रहती है और मैं मैडम का बहुत हार्दिक धन्यवाद करता हूं। नेक्स्ट श्री पी.के. बंसल जी, फॉर्मर मेंबर दिल्ली हायर जुडिशरी। मैं आपका भी हार्दिक स्वागत करता हूं। आपने समय निकाला और बच्चों को एक नई ऊर्जा मिली आपके आने से, धन्यवाद। डॉक्टर शिवानी गोस्वामी, डीन USLLS। मैडम तो खैर हमारे घर की है, होम यूनिवर्सिटी है। मैं आपका बहुत बहुत आभारी और हार्दिक स्वागत करता हूँ।
उन दिनों it doesn't apply to me. It was a course of my choice because my father was a military law expert and he is the one who encouraged me. उस जमाने में 1980s में, late 1970s में ये डिफॉल्ट चॉइस हुआ करता था। आज वो नहीं। आप लोग आज इस डिसिप्लिन को चुन के आते हैं। And why this change has happened? Because law has opened up so many opportunities for career advancement. And wo opportunities in today's context, they are not restricted to litigation, which was the mainstay during my times. Subject is restricted to the Electricity Act, the disputes between generating companies and the distribution companies or power traders. But then it's a niche area. Similarly, you have so many openings. But when we look at the Moot Court as an activity in law colleges, which has caught up the imagination of young minds in a big way over the years, and this momentum has gained only traction. There is a myth still entertained by a certain section, and this is required only if you want to go in litigation or arbitration. It's not so, because moot courting, it gives you the opportunity to be ready to give legal advice, whether you are in corporate world or you are in mediation or in arbitration or even in legislative drafting, as I mentioned earlier. And the results will show that, but taken from me, all four plus their companions in the team, the 6 persons who participated from both sides, they are true winners. Thank you so much. I'll be leaving after some time. It has been truly an enriching experience for me. Thank you.
Thank you, sir, for the thoughtful address.
Prepared than we were at that time, because firstly there was no such assistance from the college itself. Secondly, there was no internet facility so that we can find out on the net what is the judgment available. And then you have to go through the books to find out the law on the subject. Guidance was also not much, but now you are lucky enough that the management, the teachers, they all are taking care of you, and that not only assisted you but also at the same time made the competition more tough. But again, competing in moot court, and now what is being suggested, a mock trial competition will prepare you. It was good to see that for those also you were prepared and answered it very well. We were surprised, even sir has told you that it was the answer which was given from that team, that we were expecting that, and it was a good answer to that question. So well done all of you, but only one can win. That doesn't mean that the other team has not performed well, but that is the result only. That doesn't say anything that you are the one who has won. That only says that for the time being, you have won. The other one has to wait for some more time, maybe next time, which is not far away. Good luck to everybody and also to the management for holding such a wonderful Moot Court competition. Thank you very much.
Fairfield Institute of Engineering and Technology in collaboration with the National Human Rights Commission. The theme of this Moot Court competition: ensuring human rights compliance in cybercrime investigations, is of contemporary relevance. Cybercrimes are on the rise in society nowadays, and the investigating agency is grappling with the situation of how to deal with them, how to decrypt the ways and means to deal with the modus operandi of these crimes, how to decode the modus operandi, and how to take preventive and remedial measures there. Some of us might be victims of cybercrime as well. So it is one of the most rampant offences nowadays. Being of contemporary relevance, it must be holding much interest for the students, for the jury alike. The NHRC has been organizing Moot Court competitions on a regular basis in various law institutions, universities, colleges, and schools of law. This is an endeavor to sensitize the youth of the nation or the future of our country towards the human rights issues. Because of preparing for the Moot Court competitions, participating in them, and also being audience to such prestigious competitions, you are sensitized to think and ponder over the human rights issues and the contemporary issue of competition. I hear that teams from all over India have participated in this Moot Court competition. I also congratulate the administration, the learned faculty, the students, the support team of the FIMT School of Law for successful organization and conducting of the Moot Court competition in collaboration with the NHRC. One team wins, but whichever does, it teaches a lesson to the others and learns a lesson instead. Winning does not matter, participation does. You as the future of the nation are expected to be budding legal luminaries, professionals in the field. This profession that you have chosen holds immense power, and with power, remember, comes greater responsibility. I see all young faces filled with energy and enthusiasm. Keep up this good work, keep up your enthusiasm, and the quest for learning more, the quest for being legal professionals, having deep-rooted ethical values. Always remember that when you enter the professional field, it is not only your academic performance, but also the other values, ethics that you have learned that would matter. The values that you inculcate in the law school will take you a long way and will determine your future progress. I know you've had a lot of lecturing and lots of speeches have already been delivered, so I won't take much of your time. On behalf of the NHRC, I congratulate you all for being here, for having participated here, and being a part of this great learning experience. We have high hopes from you, this impressive institute, and the learned teachers, the enthusiastic students are expected to reach the highest echelons of the legal field when you enter the profession. There is a story of a seagull that I would like to share with you. First of all, let me, in brief, in a poetic form, just tell you about it. Let's see if you can guess what it is all about. Into the land of the midnight sun, around the land of morning calm, whirl around maples, witness skyscrapers, go Livingston go. If there is a seventh heaven, make it your abode. For there is little more that destiny could endow. There is little more that destiny could endow. Now, dear students, this Livingston is the story of Jonathan Livingston Seagull, written by Richard Walker. Now, seagulls have the natural tendency and limitation of flying low. But this particular seagull, Livingston, by the way, defied the natural and physical limitations to fly beyond the sky and set an example for its kin and kin. There is no limit for success, but remember to be deep-rooted in moral values and ethics, because once you lose that, the very soul leaves you. Legal profession is a very, very ethical profession. It's a very bold and strong profession. But as I said, with power comes responsibility. Always remember this. And with these inspiring words, I take the leave. Thank you.
Both the teams, they were very, very, they had a lot of caliber, lot of presence of mind, and your participation, it matters. It's not about winning or losing. Nobody is a loser here. Everybody has won. The main thing is that you have participated. You are on a journey of the legal, profession. You started those steps, and that is where it counts. So you don't have to stop here. You have to carry it further. It is your, I'll say it's a very, very, very important thing for a law student and other students also who are not participating or who do not come forward. What I say is that this is a very important thing, and a law student should definitely participate in that thing. For me, participation is very important. Undoubtedly, both the teams were very, very good today, but obviously, as the earlier speakers had said, it's only one of the parties who had to win. But for me, both were very good. I really appreciated your presence of mind, your knowledge of law, how you were analytically applying those things, how you were answering to all the queries that were, and it was all out of the blue. You are not prepared for the questions that could be asked, but whatever the judges were asking from you, immediately, and that's where it makes difference. Immediately, your presence of mind, your application of law, analytical thinking, critical thinking, everything, it does matter. So being a law student, I must say that you need to always, all students who are present here, law students, you need to question yourself. You need to answer it, and that is very, very important. So all the best to all of you. I would like to congratulate also the Institute for organizing this competition, which was very, very nice, very, very good students were there, and I'm feeling myself privileged to be a part of it and to judge this competition. So all the best for your future. Thank you so much.
That should alarm you and then fight your weaknesses. That's how you have to take it. And then when you have the exams otherwise, the result comes, nobody knows it, what is the result. But when you are appearing before the judges in the court of law or a moot court,
experience that truly reflect the spirit and the purpose of the legal education. So their association with this event has added a great academic significance and inspired our students to engage more deeply with the issues relating to the human rights, cybercrime, as well as justice. So my heartfelt appreciation goes to our respected management for their constant encouragement and unwavering support at every stage of this event. So their guidance and the belief in the academic initiative like this have been instrumental in making this competition a grand success. So I would like to especially acknowledge the remarkable effort of Professor M. Afzalwani, who truly acted as a troubleshooter throughout the entire event. So whenever
ऐसे तो हम सभी लोग हो रहे हैं, पर जाने में इसमें हमारे बुजुर्ग लोग
आइए आज की कहानी देखते हैं जो कि आधारित है डिजिटल अरेस्ट, एक फेक पुलिस साइबर स्कैम और एक ऐसा बैंकिंग फ्रॉड जिसमें ना ही किसी का पैसा छीना बल्कि इमरान क्या करे, काम शुरू नहीं होता अब तक? नहीं सर, हो चुका है, बस एक बार रन थ्रू कराना हो जाएगा। ठीक है, ये ले कार्य लिस्ट तो दिखाना और आज सीधे सीधे फोकस करना। और सुनो, स्कैम ऐसे होना चाहिए।
हेलो।
हेलो।
हाँ बेटा, कौन?
आवाज आ रही है आपको?
हाँ जी, बोलिए।
क्या मेरी बात शांति देवी से हो रही है?
हाँ।
हाँ, अब ध्यान से सुनिएगा। हम साइबर क्राइम डिपार्टमेंट से बात कर रहे हैं। आपका आधार नंबर भी लीगल ट्रांजैक्शन में यूज हुआ है और आप अभी डिजिटल अरेस्ट में हैं।
कहाँ में है?
डिजिटल अरेस्ट है। सुनिए, ये बहुत सेंसिटिव है, आपको जेल भी हो सकती है।
हमका जेल?
आपने फोन वगैरह काटा, क्या बात नहीं मानी तो पुलिस भी आ सकती है घर पे।
अरे बेटा, अकेले बुढ़िया काहे करेंगे ये सब?
अरे तो हमको थोड़ी पता है कि आपने करा है या नहीं करा है। कोई प्रूफ दीजिए। अभी आपके पास एक बैंक वेरिफिकेशन के लिए ओटीपी आएगा, वो आपको बताइएगा।
क्या आएगा?
अरे ओटीपी मैसेज पे आता है, नंबर आता है, वो बताएंगे आपको, बताइएगा कि नहीं?
नंबर?
हाँ, आया होगा।
अच्छा, 9272
9272।
ऐसे हालातों में अपना धैर्य बिल्कुल मत खोइए। और ये सिर्फ पैसों की ही चोरी नहीं है, बल्कि इट्स अ मैटर ऑफ वायलेशन ऑफ ह्यूमन राइट्स ड्यू टू साइबर स्कैम। आइए देखते हैं पुलिस इस मामले को कैसे हैंडल करती है।
दादी के साथ साइबर स्कैम हुआ है।
क्या हो गया? साइबर स्कैम?
हाँ।
सीरियस मैटर लगता है। रुकिए, मैडम आती है अभी।
क्या हुआ रामलाल?
लीजिए, आ गई मैम, केस है।
मैं मेरी दादी के साथ साइबर स्कैम हुआ है। एक वीडियो कॉल आया था, उसपे उन्होंने ओटीपी मांगा, मेरी दादी ने दे दिया। क्या ओटीपी दे दिया? हाँ, जनता को कितनी बार आगाह किया है, कोई भी ओटीपी देने से पहले डबल चेक करना चाहिए। मैं मेरी दादी के साथ डिजिटल अरेस्ट किया है। डिजिटल अरेस्ट जैसा कुछ नहीं होता। मैम प्लीज उन्हें पकड़िए। आप निश्चिंत रहिए। ये साइबर क्राइम वालों को लगता है कि वो क्राइम करके किसी डिजिटल दुनिया में छुप जाएंगे, पर उन्हें ये नहीं मालूम कि डिजिटल फुटप्रिंट्स उन तक पहुंचा दी रहती है। और आप निश्चिंत रहिए। और अगर ऐसा कोई भी स्कैम हो तो आप तुरंत नेशनल साइबर क्राइम रिपोर्टिंग पोर्टल पर रिपोर्ट करिए और उसको ऑनलाइन भी एफआईआर दर्ज करवा सकती है। और नेशनल हेल्पलाइन नंबर है 1930। और रामनाथ, रिपोर्ट लिखो इनकी।
जी मैडम।
इनका केस स्टार्ट करो। हाँ, क्या हुआ?
बैंक ट्रांजैक्शन और रिकॉर्डिंग सब ट्रेस हो चुकी है।
उनका आईपी एड्रेस और डिवाइस लोकेशन ट्रैक करो जल्दी।
मैम, आईपी एड्रेस और लोकेशन ट्रैक हो गई है। वो चांदनी चौक के पीछे एक छोटे से ऑफिस से ऑपरेट करिएगा।
तो देर किस बात की? टीम रेडी करो, हैकर्स को पकड़ने चलते हैं। चलो।
अपराधी कितना ही शातिर क्यों ना हो, उसकी पहली भूल वही हो जाती है जब वो जुर्म का रास्ता चुनता है। ऐसे ही राघव, इमरान पुलिस के हाथ लग जाते हैं। आइए देखते हैं आगे क्या होगा।
कोई है क्या? गेट खोल के है, कोई है?
कोई पुलिस वाला दे सकता है।
कोई है? पड़ोस में आग लगी है।
आग लगी है? इमरान, हाँ वो तो बिठाता हूँ। अरे अरे खोल दे, रुकिए।
चल बेटे, अगली पार्टी जेल में होगी। चलो चलो चलो।
ऐसे कैसे?
राघव, इमरान, अमन, तुम तीनों को बैंकिंग फ्रॉड और आईटी एक्ट के तहत गिरफ्तार किया जाता है।
अरे पर हमने तो सिर्फ कॉल किए थे।
कौन?
कोई तो।
तुम्हारी एक कॉल ने किसी की जिंदगी भर की सेविंग्स लुटा दी।
ये कैसी बातें कर रही हैं आप?
तुम्हें एक मजाक लगता है? अच्छा,
चलो,
मेरा मजाक
अरे मेरी बात सुनिए, लेकिन चलो।
नहीं करती। डर के आगे झुकना नहीं, पहले वेरीफाई करना। हर नागरिक को सचेत रहना चाहिए।
टेक्नोलॉजी हमारी सुरक्षा के लिए है, ना ही हमें डराने के लिए। और सतर्क रहना ही असली सुरक्षित रहना है। साइबर क्रिमिनल्स को लगता है कि डिजिटल दुनिया में उन्हें कोई पकड़ नहीं सकता, मगर कानून उन तक पहुंचने का कोई रास्ता ढूंढ ही लेता है। इंफॉर्मेशन टेक्नोलॉजी एक्ट 2000 के सेक्शन 66C और सेक्शन 66D के तहत डिजिटल थेफ्ट, ऑनलाइन इंपर्सोनेशन जैसी साइबर क्राइम्स के लिए सख्त सजा का प्रावधान है। तो आइए आज हम सभी मिलकर एक प्रण लेते हैं कि हम डिजिटली अवेयर बनेंगे और कोई भी काम करने से पहले हम इन 3 स्टेप्स का ध्यान देंगे। वो 3 स्टेप्स हैं
Stop, think and verify.
थैंक यू।
Very obvious, there's no great mystery in this. If I announce the runner-up, who is the winner is known.
Yes.
There are only 2 teams. That's the way it goes. DC 040, Amity University